We are live.
Hey, good morning. It's March 25th. We have Wedge Council here. We had previously talked about H541, I believe earlier this week, or perhaps even last week. We talked about H541 as well as S298, and we know there are bills with some similarities. We just wanted to get more a deeper clarification as to the similarities and the differences and see how we can go about harmonizing the two bills. That way our committee is not duplicating redundant work with the House Judiciary Committee. So we have led counsel here to walk us through a side-by-side of the two bills, and then we'll figure it out from there. So floor is all yours.
Well, thank you very much for having me, committee members. For the record, my name is Tim Devlin, Legislative Counsel. I apologize if I sound a little muffled today. Often I'm like mask to try everybody else being sick. So please ask me to speak up. And if you think I can't, I'm having trouble meeting people's eyes too because of my glasses. So just feel free to ask for my attention if I'm looking elsewhere. So yes, I have provided the committee with a few different materials. You have the as passed by House Bill 541 and the as passed by Senate S298. That's the Vermont Voters' Rights Act. And then also a side-by-side comparing the relevant portions of each that is in regard to interference with voters and election officials. And so I have kind of laid out some introductory things, just kind of saying a brief what the real major differences are. And then this was kind of fun and brought me back to law school. I thought it would be somewhat useful, hopefully, to just kind of break down the various elements of each criminal statute to help digest error. And so I've color coded the person committing the conduct, the person affected by the conduct that's prohibited, the mental state of mens rea, the penalties, and where there's a private right of action. So just generally comparing the two. Let's see. First, noticeable is that we have this H541 amends existing law. That is where we have 17 VSA 1972. And this is under that chapter Title 17, where we have election law, chapter 35, offenses against the purity of elections. And you may recall that 1972 is kind of a sandwiching of two different principles. We have the showing your ballot, which is prohibited. And again, this is for reasons of ostensibly trying to stop buying votes. And then we have a kind of tail end there that in H541 is struck through, and that has to do with some general interference. And that would be a person who interferes with the voter when inside the guardrail, or who, when within the building in which the voting is proceeding, endeavors to induce a voter for a particular candidate. So it's inducement, really. And that's been struck because it's kind of confusing when read with the showing the ballot provision, which is one long run-on sentence. And it's made redundant by the other to be introduced statute here in 541, that is the interference with voters and election officials, where we do have some inducement language and then some broader prohibitions on other types of election interference or interference with voters or those elected officials. Other things we have here, and drawing a comparison between the two, I should say that the private right of action is in S298, does not appear in H541. The penalties are largely the same, and that is, you shall be in prison for not more than 2 years and not fined more than $2,000 or more. And then, except for in 1934 in the Voting Rights Act, where we have a sub-provision regarding interference with voting, where violators will be imprisoned not more than 6 months or fined not more than $1,000 for each affected voter. And then I should also point out that two provisions in the Senate bill that is 1934 and 2023, both include language explicitly applying those prohibitions of conduct to elections and caucuses, where the caucus question is silent in the language is silent to sort of caucus question in the House bill. Yeah, so those are the broad terms. So looking at the side by side, we kind of first examine the language in the House bill that is 1975. This will be on page 2 of the side by side. Left column, middle row. And I think we'll just sort of read through that, and then I'll just kind of return to the language and kind of point out where it's similar to the provisions of the Senate bill. So again, 1975 reads interference with voters and election officials. No person shall intentionally or recklessly intimidate, threaten, coerce, or attempt to intimidate, threaten, coerce any other person for the purpose of A, obstructing the right of the other person to vote or to vote as the other person may choose, or B, causing the other person to vote for or not to vote for any candidate for public office or public question at any election. Or 2, and again, no person shall intentionally recklessly intimidate, threaten, coerce, or attempt to do so, public servant, an election official, or a public employee for the purpose of obstructing the administration of an election. And then we have penalty. A person who violates subsection A of the section shall be imprisoned not more than 2 years and fined not more than $2,000 in bond. So let's take that again from the top of the annotates to go up. So no person shall intentionally or recklessly. We have 2 different mental phrases or mental states. We have intentionally or recklessly in the House bill. In the Senate bill, you'll see in the blue text as it appears on the other pages, it shall be intentional. So both bills have the especially the highest level of mens rea, and but the House bill provides an option. It can be the highest, or it can also be reckless, which is the third of the. If we're going to rank all 4, that's the third. With negligently, or maybe lower than this. So, and also we have, let's see, no person shall intimidate or recklessly intimidate, intentionally or recklessly intimidate, threaten, or coerce. We see this language in 2023 in the Senate bill as intimidation of voters, civil call for action. So there we have on page 3, right in A there, the purple, it says intimidate, threaten, coerce, or intentionally attempt to intimidate, threaten, or coerce. So that does appear in both bills. Then we move, going back to the House bill, 1975, we go to, let's see, A1, any other person. So here again, in 1975, we have this way threats against or obstruction of persons voting, and then 1, and then 2, we have public service servant, election official, or public employee. So voters versus election administrators, essentially. And so we have under intimidation of voters, 1975A1A, we have obstructing the right of other person to vote or vote as any person should choose, or B, causing the other person to vote for or not to vote for any candidate for public office and public questions in an election. So the obstruction part in A1A there of 1975, that is basically redundant or repeated through the various 4 offenses we have in the Senate bill. I would just say the Senate bill are more specific examples of what obstruction can be. That's probably useful to think about it. And then B, the causing the other person to vote for or not to vote for any candidate, public office, or public question, that is redundant with 1934 right next to it. Here where we have.
Can you back up
Yes, yeah.
1 second? A1A is redundant with which?
I would say that obstruction is a broad term that would coincide with much of the activity in the VRA offenses. And the Senate bill, the VRA offenses, are all examples of obstruction and provide specificity to what obstruction kind of is without using that word. So whether that be permitting to failing to permit, or stopping refuse to permit a qualified voter to vote. That'd be a form of obstruction. Refusal to fail or tabulate the count or report the vote of the qualified voter. That would be obstruction as well. It's 1934. Let's see. If you're intimidating an election officer, that would be, we have that later down at A2 down below. That, but you have, let's see, intimidation of voters. If you are intimidating any other person, in giving a person to vote or ballot, that would be obstruction. Let's see, this is 2020.
So it's kind of bifurcated between 2022 to 2023. So instead of having one section where we say, no person shall intentionally, let's just say, threaten any other person, where it's separating it into two categories for election officers, and then the second category for voters, right? Or any other person, it looks like.
Right. So we have that in 1975, and when we're talking about voting or obstructing voters and obstructing administrators, election administrators, obstruction is a generalized term, which I think could apply to much of the conduct, or pretty much all the conduct that is described in the Senate bills. The Senate bill is just more specific than the term obstruction. I would say it drills down into what obstruction can be. So it is more or less enumerating specific types of obstruction there. And so I would say House bill has a generalized term, where the Senate bill has more specific instances provided, or examples of obstruction. And so they would both cover largely the same content.
We also have the higher mens rea of intentionally,
Yes.
compared to the recklessly.
Yes, in the House bill, there's prosecutors would have the option, either having to show that the essentially threat and obstruction against voters or election administrations was intentional or recklessly. Versus the Senate bill has to say each one of the other offenses, the various types of obstruction, would have to be shown that those were intentionally committed versus just recklessly.
So,
Can you give an example of a reckless threat versus an intentional threat?
I can give you some of the court language on
Okay.
what those means to other people. And then maybe I can brainstorm some examples. So when we have, let's see, the intentionally or purposefully, so you might otherwise hear at that point, an individual consciously desires a result. Then kind of going down the mens rea ladder, we have knowledgeable or knowledge, and that is where they are aware that a result is practically certain to follow. Recklessly, so that is consciously disregarding a substantial and unjustifiable risk that the conduct will cause harm to another. And in the threats context, it means that a speaker is aware that others could regard his statement as threatening violence and delivers them anyways. Then we have negligence, which is not aware of the risk, but probably should have been aware of the risk.
Okay. The court language actually sort of helps me clear up. I was, I think, thinking much more dictionary definition and having a hard time understanding how one could make a threat in a reckless way without intent. So that was helpful.
So, let's see. Then we have in 1975, looking to this language again. Okay, we have A1B causing the other person to vote for or not to vote for any candidate or public office or public question in the election. That will be similar to 1934, right next to it, where we have something changing a ballot. Let's see. Losing myself here, but should be done with that language. And then we move on to the public, threats against public servants, election official, or a public employee, that is elections administrator. That is similar to language in 2022. So that is at the bottom of page 2 on the right there. And that has to do with intimidation of election officers. So, would it be helpful to go through the 4 different voter intimidation provisions in the Senate bill, or as we read through those, back into the House bill, or it would be?
I think so far the picture's been painted. It's been much more clarified for me, but if committee, what do you prefer? Do you want to continue with the Senate language, or is this explanation clarify things a bit more?
It's has clarified things for me.
Do have a couple of questions on certain things.
Yeah.
So under the House version,
Mhm.
on page 2, in the 2, a public servant, an election official, or public employee.
Yes.
I'm not quite sure what the definitions of those might be, Tim.
Sure. We have some election officials defined in Title 13. I think public employee would be definitions here. Sorry, I should say public servant, generally speaking, will include individuals who are appointed or elected, not necessarily hired. Public employees would be people who are indeed hired, and then election official could be people who are drafted to be working the polls.
So under public employee, would a federal agent fall into that category?
Oh, that's an interesting question. Yes, I suppose they would be. Yeah, this bill does not specify what level of government. And so it would be read out of wrong.
And then if I might get another.
Yeah.
Under the Senate version on page 2, 1934.
Yes,
An election officer or a person acting under the color of the law.
yes.
What is?
Acting under the color of the law is a legal term of art. Essentially, provides for, again, those election officials who are not necessarily public officials all year round, but are drafted or volunteer to work at the polls, and therefore would be representing the government in some way. So when we say acting under the color of law, that is, you are adopting an official capacity on behalf of the government, and in this context, everything from check voter rolls and intake voters, to assist with any questions, process ballots, transport ballots, maintain chain of custody, participate in canvassing, those other official responsibilities of the municipality and state codified in law.
So would that also include individuals who were hired on a full-time basis?
Yes,
And
assuming they are, well, yes, it was.
so am I to understand that under 1934 that we have both a civil penalty and a criminal penalty, depending on which alleged violation takes place under B1 and under B2?
Yes, that's correct. So it'll be a civil penalty for any person who violates A1 or 2. So that is the election officer or person acting under the federal law who intentionally refuse or to permit or to fail to permit a qualified voter from voting, or refusing or failing to tabulate, count, or report the vote to a qualified voter. That would be civil. Turning to what is there's a typo here because there is no 4. But turning to the criminal aspect, person who violates subdivision A3, no A4 again, under typo, sorry, of this section, A3 is changing a ballot of a voter to prevent the voter from voting as they desire. That will be met with a criminal penalty of 6 months, imprisonment of 6 months, not more than 6 months, or fine not more than $1,000 full for each affected voter.
And my last question today is where it says private right of action, does that include both the civil aspect and the criminal aspect, and either one that fall into private right of action?
No, a civil, private right of action would be civil only.
Civil only, so if they're arrested under the criminal portion of it, private right of action does not come into play.
Correct. Where we have the civil cause of action that occurs in 2023, and this is the green text reference, and then also 2024. And so let's see what we have. This, in addition to the criminal penalty provided subsection to the reading of 2023, intimidation of voters. Such action shall also create a private cause of action. A voter who is simply affected by this shall be entitled to institute an action for injunctive limit. That is to stop the conduct, exercise every restraining order, something of that nature from the courts. And then we described where that's filed, but the private right of action is one is an equity action, not really civil, so you're not really seeking money for redress, and you're certainly not seeking criminal imprisonment, just injunctive relief to stop for intimidation is correct. And then turning to the civil action, we have communicating with all information, identical language, but it would just be injunctive relief, action in equity to prevent or to stop the communication of false information to eligible voters. But again, no monetary remedy or civil remedy that the private individual would take or seek.
Thank you. Just wanted to clarify something I might have misheard or misunderstood, but it's not an either or situation for the criminal or the civil penalty. You know, I'm saying in addition to the criminal penalty, right? So somebody could be charged criminally and then the plaintiff could do a private right of action.
Yes, so the full private rights of action are in addition to the criminal penalty.
Okay.
So let's see, 2023 intimidation of voters. There is no civil penalty, it's just criminal penalty. But in addition to that, there could be injunctive relief brought by a person. And then we have, let's see, in 2024, again, B under is the remedies or penalty section. We have the criminal aspect, and then we have, in addition to the criminal penalty provided in sub B, the private right of action. And yes, I think I know where you're kind of thinking here of, okay, well, you could be levying just the fine alone and not be basically imprisonment. It would still be, even though it's strictly monetary, it's criminal penalty, which is a civil sanction. But if there's any questions about that, I'll check with my colleagues at the Judiciary.
Maybe, what are your thoughts on how we harmonize these things here? I can start. I think it may be best, and I'm happy to, or I'm open to be persuaded otherwise. I think that Senate bill, in terms of the potential violations that we have described in 1934, 2022, 2023, 2024, they go into a lot more detail and they have the higher mens rea. And I think that is and because we're potentially treading into First Amendment issues, we want to have that higher mens rea, and we also want to be a lot more specific. And then that's also balanced by the fact that we have the private right of action for two of them. So I think.
Oh, and I just want to make a quick note, starting to break your stride.
No.
But the mens rea of recklessly was the floor of acceptable mens rea that was approved by the U.S. Supreme Court countermeasure v. Colorado of 2023. So when it comes to criminal threatening, which is part and parcel of the mens rea, the least that you have to afford would be reckless. We can certainly go about that too.
What was that case name again?
It's countermeasure v. Colorado, and that's 600 U.S. 66. That's from 2023. Very fun read. So.
Well, my initial thought is recommending to the House as they start taking this up is to copy their language from that first 1972 section, copy it onto the bill that we sent them as 298. And then presumably they'll make whatever changes they want to make to the other sections. I mean, that's the first approach that we could potentially take, but open to hearing different ideas or suggestions.
So is your, I just want to be clear with your suggestion is that we don't take out 541 and we let them put what they want in 298 and deal with it that way?
Yeah,
Okay.
more or less.
Okay.
Yeah.
I'm fine with that. Even though we have established we have no control over the House.
Indeed, we have no control over the House, but I mean, this bill was important to them, and so I don't want to have it. I don't want to kill the bill that you sent us, but if the same provisions, but more specific, are in the bill that we sent them, then they could add this first section of 1972 onto our bill, and then still get. I mean, then we both chambers would get ideally, what they're looking for in this bill. Any other thoughts on it?
I think that seems reasonable given how.
I have a problem sending these bills back to the House and let them mix and match as they best see fit, and then we'll get to reap the rewards of what they send back to us.
Sounds good.
That's good.
Yeah, great. Okay, so thank you, Tim. Very helpful, side by side, very helpful. And I'll make that request, / recommendation to Representative Malone, and then we'll see what they do with it. All right, so we can break until 9:45. Yeah, 9:45, and you have Eric in to go over the amendment that has been completed by Health